Of the year today, we welcome James McHenry, the Director of the Executive Office for Immigration Review, or EOR. EOR primarily functions as our nation's immigration court system, where it administers and adjudicates our nation's immigration laws. And we thank you for being with us, Director McHenry. I wanted to hold this hearing because I have deep concerns about how our nation's immigration courts are operating. Some of those concerns are long-standing, while others have been exacerbated by the decisions of the administration. Our nation's immigration courts handle a wide variety of immigration-related claims, from removal proceedings to asylum claims. These are complex, nuanced proceedings that require time, understanding, and care. In many cases, the consequence removal from this country is so severe that we must have significant due process to ensure that no one's rights are violated in an immigration court proceeding. Unfortunately, these concerns are increasingly being shoved aside. This, in part, is due to enormous and growing backlog of pending cases before the courts, which is now more than 1 million cases. According to the Transactional Records Access Clearinghouse at Syracuse University, the growth is largely due to the significant increase in immigration enforcement efforts over the past 15 years, which has not been followed by a similar growth in the immigration court system. Although this subcommittee has included significant increases in immigration judge teams for the past 2 fiscal years, the backlog has actually increased under the Trump administration. This situation was worsened by the recent government shutdown. The reasons for that are sadly clear. The leadership of the Justice Department has attempted to turn our immigration courts into a sort of deportation DMV, where immigrants get minimal due process on their way out the door. This administration has chosen to impose quotas on immigration judges to limit case consideration regardless of complexity, limit the ways in which immigrants can make valid claims for asylum, increase the use of video conferencing to reduce in-person appearances, and undermine the discretion of immigration judges to administratively close cases, among many other things. Ironically, those choices, supposedly aimed at efficiency, have actually increased backlog. I believe our immigration courts should strive to be a model of due process. A complete of bright spots in that effort are the legal orientation. A couple of bright spots in that effort are the legal orientation program and the immigration court help desk, both of which help to better inform immigrants about their court proceedings. We should seek to expand such programs. Despite these efforts in our current system, an estimated 63% of immigrants do not have legal counsel. We've all read stories about children, some as young as 3 years old, being made to represent themselves. That is appalling. Our immigration laws are complicated enough to native English speakers, let alone those who come here speaking other languages or who are not adults. We can and should do better than this. Today's hearing will explore the choices we are making in our immigration court system to better understand how the money we appropriate is being used and whether it is being used in line with our expectations and values. We thank you again, Director McHenry, for being here today. And yesterday, the same day, you submitted a rather glowing statement to this subcommittee. You sent an email out to your staff stating that due to the increase of cost of interpreters, you're potentially going to slow down the hiring of judges, cancel training, curtail acquisition of new space, and delay information technology improvements. I understand that costs increase, but what I find unacceptable is that you didn't come to the Congress, to this subcommittee, and openly discuss this budget situation and ask for additional resources. I assume these cost increases have been going on for months prior to the enactment of the final CJS bill. At the same time, this administration was asking for and holding a large part of the federal government hostage over funding for an unnecessary wall. So my first 2 questions for you are, when did you become aware of the shortfall? in the budget? And why didn't you request more funding for the interpreters' contracts?
To answer the first question, interpretation has been a challenge for EOIR throughout its history, and it sort of ebbed and flowed over the years. In the early 2000s, we had difficulty obtaining interpreters, and at that point had to switch to telephonic interpreters on a relatively frequent basis. Again, over the years over the time, the challenge has come, gone, and come back again. Right now, the challenge, however, is driven primarily by our successes. As I alluded to, we've hired more judges, we're completing more cases, we're holding more hearings. The number of hearings that for non-English speakers have risen by almost 60% in the past 5 years. These, of course, increase interpreter costs because we are completing more cases and holding more hearings.
So you're saying that it's not possible to have a hold on finding out how many interpreters you will need, or you're always short when you're reaching out? How many languages do you deal with?
Our interpreter contract, I think, calls for at least 350 different languages. And we have attempted to address the interpreter situation in other ways. For example, last year we advertised for full-time interpreters to hire at the courts. Unfortunately, to be a full-time interpreter at EOR, as outlined in our language access plan, requires a great deal of experience, particularly in a judicial setting. So when we test the interpreters, unfortunately, we only got a handful who were able to successfully complete the examination. We've also been looking at stacking and docketing practices to ensure that languages are grouped together so that we're not wasting the interpreter resources.
Now, the memo you sent out putting forth these bad news to the staff, does that have a starting date, an implementation date? And
as you know, the budget was...
Yeah, I don't want to be in a situation here where I'm telling you, if you talk to us, we're going to take care of the problem. That's not the way we work on appropriations. We have to find out where the money's going to come from and so on. But I think at the minimum, from what I heard Mr. Adderhall say and what I've said, we would have been open to discuss the situation and find out going forward how it can be helpful, either, in some special situation that comes up in Congress or in the next year's budget. So I'm just not understanding how there wasn't an alarm that this was going to be a problem, and then an email comes out saying, we have a problem that Congress didn't know about.
No, I'm happy to take that message back to the department. I think the department is pleased to hear that. This committee has been extremely supportive of EOR in the past, especially in the recent past, and none of the success, none of the things that I alluded to with hiring, with case completions, all of our efforts are almost entirely attributable to that support. So we're very grateful, very appreciative, and I'll definitely relay that message.
Thank you. Last year, then Attorney General Sessions testified that immigration judges, quote unquote, agreed to use case completion goals as part of their job performance evaluations. Is this true? Did immigration judges agree to the use of case completion goals as part of their job performance evaluations? I always preface a lot of these comments by saying I'm not a lawyer, I'm not a judge. I played one on Law and Order once, but that doesn't count. But it would seem to me that democracy and justice should take whatever time it takes. I'm one of those few people that says, gridlock may not be a terrible thing, because there are places where the budget is always on time, because one person decides what the budget's going to look like with a little group. We have democracy, and democracy means you get elected, I get elected, we disagree, and it may take a little longer to reach that situation. But the whole idea that, you must complete so many cases or else you're not doing a good job, just doesn't make sense to me. Was there agreement on the part of the judges and everyone else at EOR to do this?
I can't necessarily speak to what Attorney General Sessions may have said because I'm not familiar with the full context. But what I can say is that prior to last year, the collective bargaining agreement that we have with the Immigration Judge Union prohibited the use of numeric performance measures. We negotiated that with the union, and as part of that negotiation, that section was withdrawn. That then allowed us to promulgate these performance measures at the beginning of this current fiscal year. To our mind, we understand the concerns and we've looked at them very closely, but we don't consider them quotas, and we don't consider them quite as black and white or quite as stark as perhaps they've been portrayed. In the collective bargaining agreement, there are 6 discrete factors that we do consider, plus a 7th catch-all to sort of account for any situations, any anomalies, any weird trends that may be impacting a judge's performance.
Well, but that brings us to the next part, which is how can you ensure that judges don't feel pressured to take shortcuts within the system in order to meet what is being asked of them?
To our mind, again, we're sensitive to that concern, but to us it's sort of a false dichotomy. The regulations require that the judges issue decisions in both a timely and impartial manner. We don't see the two as in tension, being able to do things timely and impartially. And these performance measures, they're also not unique to us. There are a number of other agencies that have implemented our other components, the Board of Immigration Appeals and the Office of the Chief Administrative Hearing Officer. They also have performance measures or case completion goals. And we won't have the results, we won't have the outcomes, obviously, until the end of the fiscal year. But so far, we haven't noticed any significant issues that have come up with them so far.
Well, let me just then be on the record for you to take back also, based on what you said before, that we want judges to be judges. We want them to judge. We don't want them to have to meet a quota or meet a timeline in order to deal with justice. That justice doesn't work that way. If it takes longer, let it take longer. Or, you know, let's talk about more judges rather than a number that doesn't fit. And lastly on this, do you anticipate that the use of these performance goals could be used as grounds for an appeal of an immigration case?
Again, that's an issue that's been raised and that we've looked at, but by itself, we wouldn't expect so. First, because our judges are professional. They know that the law says that they don't make decisions based solely or entirely on those goals. They know that will lead to reversal. Additionally, we can't control what arguments people want to raise, but we've trained our judges. They understand. Many of them come from other systems that have performance measures or case completion goals, and they understand, as I alluded to, how to balance being fair and impartial and respecting due process, and also providing timely adjudications of the cases so that these individuals don't have to wait any longer than is absolutely necessary to get a decision.
I want to ask one last question here and then get on to the other members and Ms. Adderhold. We just had the longest government shutdown in history. What has this done in terms of the backlog of immigration cases? Can you tell us the current backlog number, as well as how many cases have been added to the backlog as a result of the shutdown? How long will it take to get back to the pre-shutdown level?
The current pending caseload is about 850,000. We wouldn't necessarily say those are all backlogged because that includes cases that were filed yesterday, the day before, a few weeks ago, that haven't been pending for that long. It also includes detained cases, which generally move much more expeditiously. In terms of the shutdown, for us, it's not a question of added cases because non-detained cases weren't being adjudicated, they weren't being filed, so it's hard to say. What we can say is that we had to cancel approximately 60,000 hearings during the time of the shutdown.
And when you canceled them, were you able to get back to those folks after the shutdown and tell them that you were ready to hear their cases, or that they were still on schedule to have their cases here?
The courts are in the process of rescheduling those. They've been working overtime since the shutdown ended to get that done.
Because from what we understand in the committee, during the shutdown, many may not have been sent written notice after the shutdown that the cancellation now is over and they can be taken care of, or at least dealt with their issue.
There was a hiccup the first week after the shutdown ended because we didn't have time to necessarily get notices out. We also had a couple of courts closed that week due to weather issues that delayed us. But we think those problems have largely been resolved since then.
Thank you, Ms. Adderhold. Director, were you involved in any way in the decision by former Attorney General Sessions in the matter of A and B case, which limits the use of domestic violence as grounds for an asylum claim?
I'm familiar with the AB decision, but it's another one that is, that is very much in active litigation. In fact, part of it has been enjoined recently, so it's not appropriate for me to talk about it.
You support removing the category of domestic violence as a justification for an asylum claim?
Again, asylum claims are individual, they're very much fact-specific. There's been case law on domestic violence claims going back to 1975, so it's not an issue that's particularly new or particularly novel. Our judges know that they adjudicate the cases based on the facts, the evidence, the claims before them, and in accordance with whatever precedent they happen to be bound by.
Let me, do you think at any moment you'll be able to comment further or be involved more, or you think that while it's in the courts, we should just stay away from it at all?
On the issue of matter of AB, the court case is pending and it's being challenged in different areas, or it's being appealed in different areas. I don't know how long that process will take.
Thank you. The administration recently announced a new plan to require those seeking asylum at our southern borders to remain in Mexico while awaiting adjudication of their asylum applications. This raises a whole host of potential problems for our immigration courts. For instance, how does the court provide notices to appear to these individuals? How are they to appear to have their claims heard? And as I was reading this question, as I'm reading it now, I'm thinking also, and maybe this is totally out of left field, but if some of these folks are running away from violence and from physical danger, I think the last thing they want is their local postman knowing they're getting a letter or something from the U.S. Asylum Office or something, or Immigration Office, because that'll target them as being involved in trying to get out. Maybe I'm thinking too much, but you know, those folks are facing a lot of hardship. So how do you think this will work out?
Notice is always a concern for all of our proceedings. I can't speak to the migrant protection protocols specifically because, again, unfortunately, there's pending litigation going on. But notice is required by our statute and by regulations. And any cases that are filed with us, we make every effort to ensure that the respondents do get proper notice of whenever the next hearing is.
And are you, was your office consulted on this decision to keep people in Mexico? And by the way, is it people seeking asylum from Mexico, or to anybody who made it to Mexico from any other place?
The MPP is a Department of Homeland Security initiative, so I can't speak to it comprehensively. My understanding, at least based on how the statute is, it's individuals who are coming from a non-contiguous country, so not from Mexico, who apply for asylum at a port of entry or at the border, and then are allowed to wait or remain in Mexico until their cases are heard.
Were you consulted at all, and your office consulted at all in putting this together?
The Department of Homeland Security initiated the policy. It's their policy. Obviously, it impacts us, so we've coordinated in terms of understanding where the cases are going to be.
And let me ask you, is EOR facilitating access? How is EOR facilitating access to counsel for individuals awaiting adjudication of their asylum claims?
Under this protocol or just in general? As I've indicated, our judges, if someone shows up who's unrepresented, the judges will explain the law to them, they'll explain their rights to them, including the right to get counsel at no expense. If they have a claim for asylum and they don't have representation, which is only about 20% of our cases, by regulation, the judge is required to discuss the claim with them and provide applications and information to them so that they can apply for asylum or withholding or whatever protection they're seeking.
And on the one we were discussing before, is the target time frame, there's a target time frame for adjudicating these cases? And what is reasonable? What's a reasonable time?
I'm not sure I follow. Which types of cases?
Mexico issue, I'm sorry.
Oh, again, they may fall under our existing priorities, but the cases haven't actually started yet or been heard yet, so I'm not sure how they're going to play out.
They haven't been assigned yet They haven't started yet. you
The
said.
cases have been filed, but we haven't had the first hearing yet.
So do you know how many judges have been assigned to these cases?
They're assigned to courts in terms of how many judges would be hearing them at particular dockets. I don't know.
Hey, Mr. Director, were you involved in any of the meetings, either with others at the Department of Justice or Department of Homeland Security, where discussions of the family separation policy were held? And did you support the adoption of this policy?
Actually testified a little bit on this last week. The department didn't have a family separation policy. The Attorney General, following upon a policy he issued in 2017, which followed an executive order issued earlier that year, issued what's called a zero tolerance policy, which is a prosecution policy that directed prosecutors, AUSAs along the border, to accept cases referred by the Department of Homeland Security for illegal entry. Because it's a prosecution policy, certainly I was aware of it, but it's not something that we're directly involved in.
Yeah, but the policy itself resulted in the separations. So what was the involvement of your agency in it? I mean, we have many issues to discuss on immigration. We all know that. But I think even people who haven't spoken on this, and I'm not putting words into anybody's mouth, especially, my friends on the other side, no one likes children being separated from their parents. This morning we have a report that 471 parents were deported without their children. I mean, that's something that we're not supposed to be doing. And, again, I'm not a lawyer, but I'm wondering, does that qualify that we kidnapped their children if we did that? What did we do? So that caused the separation. And is there anything in place at your agency to try to be part of remedying whatever harm has been done?
Part of this is in litigation. It's still ongoing litigation, the Miss L case. And we certainly work with our litigators to provide them with any information that they may need in terms of the reunification efforts. The zero tolerance prosecution policy itself, however, doesn't directly affect us. Individuals who are prosecuted under the policy, it doesn't prohibit them from applying for asylum or any sort of protection to stay here. So we would get their cases whether they're prosecuted or not.
Thank you on asking questions. And I just have a personal note, we should every so often when we deal with this immigration issue, put ourselves in the shoes of those people in those countries and what they're going through. And I once either sarcastically or very profoundly said, if you don't want an immigration problem, because I don't call it, an immigration issue, because I don't call it a problem, then don't advertise. We tell the world that we're the greatest country, and we are. We tell the world that we have the greatest economy, and we do. We tell the world we're the greatest military, and we have it. And we tell the world that we're the land of opportunity. And then we're amazed that people would come here. There's something inconsistent with that. So how to resolve the immigration issue? Many ways. But maybe one of them is not trying to make the whole world think that we're the greatest thing on earth, which we are. For the record, I don't want to get a tweet saying that I hate my country. This is the greatest country, but that's why we have immigration issues. Thank you so much, and thank you to the panel. Thank you, Mr. Adderholm.
Thank you. Thank you.